It's truly an honor to have Judge O'Sullivan, Maureen O'Sullivan, here with us as a guest in our podcast. And I just want to welcome you.
Thank you. I'm happy to be here.
Before we start with questions, I've sent you a couple questions. I wanted to ask you, why did you become a judge? What was that inspired you to become a judge?
Well, I had practiced immigration law for many years at that point, for about 25 years. And it was one of the things I hadn't done. And it was appealing to be in the position where you're actually making decisions to help people. And as a lawyer, as you know, you're trying to convince a judge or the immigration service, whoever's adjudicating the case, to make a ruling in favor of your client, but you don't really have control over that. And as the judge, you do have a lot more control, and that was an appealing aspect of the job.
That's wonderful. And how long were you in that position, and where, what court?
I was an immigration judge for 14 years. First in Los Angeles for 4.5 years. Then I transferred back to Boston, which is where I'd been in private practice, and worked for another 10 years.
Yes, and I just wanted to mention, Judge, the reason why I say it's an honor is that you're really one of the top favorites of the legal community in general, not just mine. You're just, truly a blessing. Most of my colleagues say that you're an angel, and I agree with that, because you really have brought hope not only to, in court we call respondents, we call them clients here, but you brought hope to families, and you always looked at cases with human perspective. You always treated us with respect, and I think that was also something that I will carry on throughout my legal career. So thank you for that.
You're welcome. You're welcome. Well, that was my goal.
And so let's talk about behind the scenes. What was a typical day as a judge?
Well, it's very busy. It's extremely busy. Most of the time is spent actually in court. Mm-hmm. And judges have, as you know, essentially three different types of hearings. One is called a master calendar. Those are the big hearings with many, many different people. Often it's the first time a person comes to court, mm-hmm. and they are coming in response to a notice. So the judge is making sure that they're there, checking their address, seeing if they would like time to try to find an attorney. If they already have an attorney or they don't want an attorney, maybe giving a deadline to file an application, and essentially organizing the case. And those are huge calendars full of many different people. A lot of people don't have lawyers, and there are many different languages, so there are also many interpreters involved. The second type of case is called an individual hearing. Those focus mm-hmm. on one person's application for relief, such as one person or one family's application for asylum. It's like a mini trial where the individual gives evidence, it testifies, and then is cross-examined by the attorney for the Department of Homeland Security. And the individual can present evidence, the Department of Homeland Security can present evidence, and ultimately the judge makes a decision. Mm-hmm. The third kind of hearing are bond hearings. Only judges that handle detained cases do bond hearings, and that's where they decide whether a person can be released on bond and what the conditions of that would be. All the time spent out of court is basically spent preparing to be back in court, reading applications, reading supporting documents, mm-hmm. and motions that might be related to those cases.
Seems like a lot of work.
It's busy.
And it's busy. And I recall when I started as a lawyer, to me, especially the master hearings, this is way before COVID hit, and the courtroom was packed, not just with, clients, and it was attorneys coming from out of state. And, and sometimes each court or judge has their own norm and how they expect presentation. So it's a lot. And one thing that I really appreciate that you also did, and something that I always felt like this is something I hope to do to others, you're always respectful, even with out-of-state lawyers. And because some judges don't have the patience, especially if a lawyer is not doing something that normally is expected in that courtroom. So that's good things.
Oh, thank you.
So let's talk about the emotional part of being a judge. I'm sure you've come across cases that were, heartbreaking, stories that really might have caused you to think about something that maybe happened in your personal life, or have you seen it happen with a family member or someone you loved? How did you deal with high-stake cases?
Well, they are difficult. If you knew in advance that it was going to be a high-stake case, then, of course, carefully reviewing the record, supporting documentation, any sort of medical evidence, psychological evaluations, other supporting evidence. Perhaps more difficult was when you didn't know how emotional a case was going to become, and it evolved in the middle of the hearing and became very, very emotional. And really just trying to be patient, give the people time, take breaks for yourself, for the lawyers, for the individual people. But it is, immigration cases are very emotional. And I knew that before coming to the job because of practicing in the field. And as you know, because it's very important to people about whether they can stay in this country or not.
Yes, yes. And also, I know for a fact, seeing children too, right, in courtrooms and as young as like toddlers, it's just mind blowing, right? Because it's like the toddler's also a respondent, a defendant per se, right? If you were thinking criminal context. Did you ever feel constrained by the law in ways that made outcomes difficult?
Yes, and that's something that I think sometimes the public or people who are not immigration lawyers don't understand, is that everything in immigration court is constrained by the law, and each type of application has certain requirements. So the person has to meet the requirements for that application before there's even a chance that the judge could make a decision in their favor. And sometimes people don't understand that the judge can't make up a remedy just because the person seems like a deserving, good person who I might think should be allowed to stay in the United States. They have to meet the legal criteria. And only then could I make a decision in their favor. So there were many sad times where I really liked the person. I could see they would be a good person to live here and genuinely wanted to stay, but it wasn't possible to make a decision in their favor because they didn't meet the basic legal requirements.
Yeah, no, I agree with you. I've even myself as a lawyer in cases where very deserving person, they've contribute to our communities. They have children born here. And then when it comes to making arguments to like a viable case, they didn't meet the requirements. They didn't meet the eligibility requirements, whether it be the 42B, which is what they call the 10-year law here, or an asylum case. And it was very disheartening to not be able to find an option. There was the option of PD, what we call prosecutorial discretion, and where we could kind of pause cases for some time, and especially if it's a parent who has children here or someone going through some treatment. And since that's been taken away over the years, and it's hard to see where we as lawyers have to tell the client, your only option right now is seek voluntary departure, because there's really no case for you at this time.
Right.
Yeah.
Right. And it is too bad, that prosecutorial discretion program, and there were various phases of it under different presidents.
Yes.
Was really a godsend for a lot of people, and for the judges too, because judges don't want to deny a case for a good person.
Yes.
It is too bad. Hopefully it will come back someday.
And especially for a person also who may not at the time be eligible, let's say, for adjustment, but in the future they will be, and you could use that option, and that's no longer an option. What's the most common reasons and cases are detained? And we can actually talk about asylum cases. Do you mind pointing out some pointers, especially for new lawyers, because I'm sure we're going to have new lawyers watching this podcast, and law students who follow us as well, is what is the most common reason an asylum case gets denied?
Overwhelmingly, it's lack of nexus. Now, nexus is a term of art in the immigration law, and essentially what that means is the connection of the harm that the person has suffered or the person fears to one of the 5 protected grounds in the law. They have to show that persecution they fear or they already suffered was on account of race, religion, political opinion, nationality, or social group. And each one of those 5 things has been interpreted over the years in many cases. So sometimes it's not obvious, but they have to make that connection. If they don't make that connection to one of those grounds, no matter how serious the persecution they suffered, say, for example, the person was mugged and suffered horrific injuries, lengthy hospitalization, multiple surgeries, but the reason for that injury didn't have anything to do, or at least they couldn't show it was on account of one of those 5 reasons, that there's no nexus that the judge could use to approve the case. So that's very, very common. And often people who don't have lawyers don't understand that. Often people who are not experienced in immigration law don't understand it and don't realize that certain things that you might not at first think could be a nexus, like family, actually have a long history of being recognized in our cases, so that if that woman who got mugged it wasn't just bad luck when she was walking down the street. If she was attacked because someone was trying to get back at her because of her family, then that changes it into an approvable case. But she has to make that connection to show the nexus, and that's often what's sadly lacking. But if she can make the connection, then you're looking at a case, something that turns into a possibility of being approved.
How about when a lawyer thinks they have the best, argument or the what we call the PSGs, protected classes or groups, and the nexus, they articulated this beautiful, let's say, brief, but during the hearing they come up with new ones. Was that common for you to see, or do you think it's set in stone what you file, or can it change or be added on?
I would allow people to add on during the hearing. So the PSG, the particular social group, is one of those 5 reasons. Often people would be making slight modifications. The case might start out as woman in a domestic relationship. Then as the case went along, it might become a married woman in a domestic relationship who cannot leave, or it would turn into Guatemalan woman in a domestic. Then as the case law became negative for that description of a social group, people might change it to family.
Yes.
But it was really all slightly different ways of looking at the same thing.
Right.
So to me, it wasn't an allowable modification, because I wanted to give the person the maximum chance to frame the case in an approvable way under the current law. And sometimes cases go on for a long period of time.
Right.
So when the case started, they might have thought this way of framing the particular social group is going to be best. By the time the case is being decided, the law has evolved, so it's not best.
Right. And that's a good point, because applications are usually filed, let's say if someone's applying for asylum today as a defense of asylum, so before an immigration court, and they file, let's say today in 2026, their individual may be 2028, and things change along the way. Do you recommend that attorneys prepare a statement along with their applications and outline the PSGs and the written statements, or do you recommend that they do not file a written statement with their application?
I do recommend, because now, as you know, some case law has evolved at the Board of Immigration Appeals, saying that if a case as presented on paper, and even considering it in the light most favorable to the individual, does not appear to be approvable, the judge can pretermit the case, can just cut it off at the beginning without allowing a hearing to go forward. And so without a description from the lawyer in the beginning presenting an approvable theory of the case, this could potentially happen. But you would want the lawyer to leave room for later updates or modification of that theory of the case. And I think it is super important to do all these things in writing, which is another reason why it's so important to have a lawyer, because if the judge rules against you, then it's still in the record. You've made the record. You haven't lost that chance to put the argument in the record for appeal. Whereas if it wasn't in writing and you were just planning on saying this at the hearing, an individual or an attorney, you may lose that chance entirely.
Yes, I think one of the concerns that attorneys have sometimes with written statements is that the client, with all good intentions, will give us a story,
Mhm.
but then along the way or years go by, they'll start remembering other facts or change them a bit because of trauma,
Yes.
right? And sometimes given certain information or even misstating something that may appear to them insignificant, but it may affect the credibility of their case. So how could we fix that? Like we file the application with the written statement, and then 2 years later, the client said, oh, no, actually, I was not attacked in my neighborhood. It was actually at my grandmother's farm and so place. I confused. It was actually not 2019. It was 2015. And how do we go about fixing something like that?
Well, it is hard, but with
Mm-hmm.
another written statement.
Okay.
And so you want to have another written statement where the client explains. I realized that it was this other year because whatever the actual explanation is, since I
Yes.
came to the United States, I started to get counseling and therapy, and my memory, which had been very fuzzy on this, became clearer. Also, I realized maybe something tying it to something in the person's life.
Mm-hmm.
I realized at that time that was before I had had my child.
Yes.
And the child was born in a date which is absolutely certain. So it couldn't have been the first date I
Right,
gave you.
right.
It had to be earlier than
Mm-hmm.
that. Or I realized it was before some, my husband left to come to the United States, and that was in this year.
Right.
So, but the important thing is put in the explanation and put it in writing by the client, giving the most favorable reasons, because the last thing you want is to be there in the hearing and have a different story coming out, because now it does look like they're just changing the story, or they might be embellishing.
Right.
And maybe the judge will still be skeptical about whether it's true, but you have to try. And if it's in writing
Right.
and you have the explanation for why it changed, or maybe I asked my mother to get the documents, my medical records, for the treatment I had after that attack. And when they came, I saw that they actually said this year.
Right.
And after thinking about it and reconstructing everything with my lawyer over time, I realized that this has to be the right year, not the one I'd previously set. So something along those lines.
Judge, as you were speaking, I'm glad you're explaining it this way. You're kind of explaining it as a lawyer as well, because you were also a lawyer before you became a judge, and you were also in the field of immigration, my understanding. And so we have judges nowadays that have no experience in immigration or in immigration as a lawyer. So that's really important to hear those pointers, because you're also speaking on behalf of, as your lawyer, as you represent your clients. But let's talk about the pro se individuals. So the individuals that have no means to hire a lawyer, because we're seeing that more and more in days, especially during consultations, even when we offer like low bono fees.
Yes.
I've had people not sign a contract, or I have to direct them to a nonprofit, and sometimes nonprofits are on this wait list. And so we want people to be empowered as well to draft a strong declaration, a statement of their case, because I will never forget, I had a client in detention. Actually, he was not my client while he was in detention. He fought his own asylum case and won. And I could not believe it, because I did his consultation when he was in detention, and he wasn't able to hire our services. And so he fought his own case, which I do recommend having an attorney. But this was one I'll never forget, because I asked him once he was released, he wanted to continue. He wanted to know what would be moving forward today. He has a green card, because after you win asylum, if you file within a year or meet one of the exceptions, you can, after a year, apply for a green card. So, and I said, how I'd like to see a copy of what he kept copies, which was very interesting, because especially when you're in detention and to get copies, it's almost impossible. He had a copy of his statement, and he really made a case. So let's talk about common mistakes people make when they write statements. And let's focus more on people that are doing it on their own. They fill out the application, and now they want to tell the judge their story. How would you guide someone who needs that guidance of how to write a strong statement for their case?
Well, to tell the whole story. So oftentimes when someone is not represented, they would focus on the last thing that happened that caused them to leave the country, such as I was riding on the bus and I got robbed and it was the third time. I couldn't stand it anymore. I left. And that's not a case. No judge in the world can grant that case.
Correct. Yep.
It's crime. It's fear. It's sad situation. I wouldn't want to live there after that either.
Right.
What you have to look at, what happened before that? Why was it the third time that person got robbed? Now, maybe it's because of their race. Maybe they were being targeted because they were indigenous or because they were black or there was, terrible crime against a certain minority.
Yeah.
But they need to tie it, remember, back to one of the 5 protected grounds, which is one thing I would say. Even if you can't afford a lawyer to represent you through the whole case, go for a consultation with someone like Eloa, someone who can explain this to you and explain what these 5 grounds are if you're talking asylum and which ones might apply to you after hearing the whole story about your life and all the things that you suffered, not just that last little thing or not so little that caused you to leave your country, but maybe there really are long-term reasons why you were persecuted or why you would now have good reason. Maybe your family supported a certain political party and the opposing political party is now in power. And people who supported your family's political party are now being purged or having some terrible repercussions, being jailed, being subject to backlash. So don't assume that something's not important and try to put as much as possible of your whole story in the statement. And the same is true with the application. Make sure that you put all truthful information in the application, including sometimes things that are embarrassing. Have you ever been arrested? Have you ever been charged with any kind of crime? People, so common would be, no, never, never. Well, then the lawyer for the Department of Homeland Security would say, well, I have
that time.
Exactly. I have a record 3 times you were charged with driving without a license or driving with a suspended license. And the person would say, oh, well, I didn't know they meant that. That was, I paid my ticket and it got resolved. But you have to say it up front on the application and then present the proof that you paid your ticket and it got resolved. Because otherwise it can tend to make you look like you're not telling the truth when really it's not a big deal. It should not be a big deal. You must disclose it in advance. So those are a few tips.
Thank you. That was great. And credibility is number one in my opinion. That's what I tell my clients. It's best to be honest than having to explain something that just would have been preventable. Like, obviously there are times where we're prepared for other complex questions and whether it should be answered or should be shared. And that's up to you and your attorney to work out. But when it's something minor, you should definitely share that information. Judge, can you describe a moment where you had to make a very difficult ruling? Like, is there, I'm sure there might be more than one situation, but is there one that you could share with us? Or
well, it's really what I said in the beginning that, we saw many people who say they were applying for what you say it is often we call cancellation of removal, but it requires 10 years physical presence in the United States. There's technical interpretations of those 10 years. Say a person went back to their home country and came back in during those 10 years and stayed a little bit too long out of the country. This comes out in the hearing. It will turn out they don't have the 10 years. So even if they have a child with this very serious medical condition that needs treatment here in this country, they're lacking that basic requirement of the 10 years. The judge would have to deny the application. The judge might be able to give time to see if there's any other kind of application that could be filed. But that type of thing did happen, and it would be very heartbreaking because clearly the person did not know. And then when it came out for the lawyers, often the lawyer, if there was a lawyer, also didn't know. And it would be, it could be very sad.
Yeah, no, it's the three requirements: the 10 years, the good moral character, and the exceptional unusual hardship to the child in that case. And wasn't there a case, I don't recall the board case, where you'd have to have exactly 10 years? You can't have like 9 years and 364 days, which is,
You can't.
it
That's
has to
exactly
be
right.
exactly 10 years.
Can
Yeah,
be more,
yeah,
but
it
not
can't be
not
less.
1 day less. That's right.
Yeah, and
Yes.
then I have those consultations, if not weekly, almost weekly, because I have the child or the spouse or the parent who needs the treatment, who needs to be here, the U.S. citizen child or green card status parent. Usually it's a parent who has green card of the child born here, or spouse going through. I have situations where they're going through cancer treatment, and it's like a great case, but they don't have the 10 years.
And, on that topic, I think, especially for anyone who wants to apply for this 10-year remedy and is thinking maybe they would be a good candidate, you should be very, very careful because
Yes.
the law on this has become harsher and harsher. And I know in the past, some people who had U.S. citizen children would apply for asylum, really hoping that they could accumulate the 10 years and ultimately switch their applications when
Yes.
they got in front of the judge and apply for this 10-year remedy. Now the standard of what it takes, how much hardship
Yeah.
a family member would have to suffer if the case was denied has gone up and up and up and
Yes.
up in the last couple of years. So I would strongly caution you against doing that
Yeah.
because once you're in a removal case, you're in and you can't get out. So you either have to win a case or you have to leave
Yes.
the United States. So be very, very careful with that. And that's, again, something where I think it's really important to consult a lawyer.
And Judge, thank you for sharing that information, because in our communities there are notarios, non-lawyers applying for the I-589 application with that promise that the individual will be able to get a green card in the future. And if they apply for this application, often not knowing what the application is about, asylum application, and they promise the work permit, the social security card. So I have clients that I'm now representing that started that. I wouldn't call it a scam, but that, hope, promise of this will happen, you'll get this. And now they're in removal proceedings and they don't have the hardship part. The child is healthy, the child's a good student. There's not anything we can pinpoint that would make it very beyond extreme. And so in talking about that, it's, I believe, only 4,000 visas available or cases can be approved nationwide. So I think it was about 6 months ago, to 8 months ago, I had a client in detention in Texas. And when we started the case, the judge was a bit kind of standoffish. She's like, well, I don't usually approve these cases. So just, this is what I want. I want documents for this. And this is our master hearing. And he gave us the individual date. And then the individual date came and he said, since 2017, I've only approved 7 to 8 cases. 27, and I'm talking about like in 9 years, he's only approved 7 to 8. And he did approve our case. It's a very sad case and very deserving family. I mean, every family's deserving when it comes to that point. But this one was a very sad case. And I'll never forget that, because that's how important it is to, when you are filling out an application, whether it's a lawyer or non-lawyer, is to really know what you're signing on for. Do know that, it may look really good. My mom always says that something may look good. You got to look into it, and then, weigh it out, because also we'd had cases here where people consulted us where they're still, with their asylum application pending with the asylum office, the child's no longer 8, the child's 20 years old and the child is aging out and they're still not in proceedings. And they thought they're going to get a green card. Again, that promise that, if you file this application, so be very careful, right, when you're filling out something, even if it seems to be beneficial, consult with an attorney.
Right. And if you did have an application submitted for you by a notario or whoever, say years ago, and now you're going for an actual final hearing on that application and you can't afford to have a lawyer, make sure you read it. know what is in there, because this would also come up, that it would, of course, the application is written in English.
Yes.
And then the person would start telling the story, which is about why they're afraid to go home, and it's not matching what's in the application.
Yes.
And then they would be questioned about this, and the individual would say, well, I didn't know that was in there. Well, it's your application. You have to know what's in there, because if you now tell a different story, you can be made to look like you're not telling the truth. So if you're going forward, I hope you're not going forward with a final hearing without a lawyer, but if you are, make sure you read every single paper that's been presented on your behalf so you know what's in there. And if it's not true, you tell the judge right away when you first go in so you can correct it.
Thank you, Judge. So we talked about filings of applications, statements. How about during testimony? And it usually happens when the client is on that individual hearing date, and it's usually about 3 hours. I've had cases where the judge has to set another date, so end up being like 4 hours, 5 hours of just testimony, cross-examination. But are there things that people, when they're on the stand, say that actually hurt their case? What things they should avoid?
The first thing is saying no criminal record. And that's really, it's because it's a misunderstanding.
Correct.
They're thinking what they had was not a criminal record.
Right.
But some people, if someone's trying to hide a criminal record, it is going to come out.
Yes.
And if it comes out without their having disclosed it, it's always going to be to their disadvantage.
Yes.
So that's one thing. But another thing I saw a lot is people answering to a question, I don't know. This is your case.
Right.
You have to know.
Right.
Or you have to know why you think of this happened.
Yes.
Why did this person attack you?
Right.
Why has this person threatened to kill you? Now, of course, you can't get inside that attacker's mind and know exactly. Don't say, I don't know. It's your case. This is your day to explain why your case fits within one of those 5 reasons. What did the attacker think about it before you come to court? And practice with your lawyer. What did the attacker say to you when he or she was attacking you? Did they call you racist names? Did they insult you because you were the wife? Did they say, you're my wife and I can do with you whatever I want? So that's showing that because you were in the family is one reason why the attacker did this to you. Or if the attacker called terrible racial epithets to you as they were attacking you, that shows that your race was a reason. So think about this in advance. And, you don't have to be a mind reader, but just you need to be able to say, this is what I believe. Is the reason why I was attacked because of and then tell what they said to you and why you believe that. And the same is true about the documents that are in your record. You need to have read those, whether you have a lawyer or don't have a lawyer. And if you don't read English, get someone to sit down with you who does read English. So if you look at this police report and it's got a different date on it than you said in your affidavit, you need to be able to explain that. Which one's wrong? How did it get wrong? Now, maybe you don't know why it's wrong. Maybe you just asked your mother to go to the police station to get this document and it's not right. But you need to be able to offer some explanation. Same about medical records. Or why didn't you put in the records? You need to be ready with explanations. Another very common thing is, well, when you got attacked, who was right? You were with your sister, right? Well, did your sister file a statement for you? No. Well, where does your sister live? Oh, well, she lives in Worcester. Well, where is she? I didn't know. Now, I didn't know. It's your case. This is your day. Have your sister write a letter. Have your sister come to court with you, if possible, if she's in a position where she can do that. Now, maybe no one will want to ask her questions, but it shows that you're bringing forth all evidence to support your case and make as strong a case as you can have, whether you have a lawyer or not.
So important to know the details, because that particular particular case I mentioned, Texas, one of the questions that I noticed the judge was very much interested if the client actually knew the diagnosis of the child. It was like mind-blowing how this client knew even the details of each diagnosis and how he knew like what medications. And there was like, I don't know, like 5 or 6 and names I've not heard, which, I've heard when I was studying the case. And I'm like, I had to Google it and be like, okay, this is what it is. So he knew it.
Yeah.
He went this very broken English. He knew how to pronounce it. So that to me was what I think made the case. The judge knew that. He knew his son, knew what he needed and why he was a present father. So, yes, I 100% agree. All right, so let's go back to the asylum cases involving now victims of trauma, victims of, just very serious persecution or torture. How was your approach with them, and how was the, how are their cases handled?
Hopefully the whole story is presented in writing, in detail, in writing, and accompanied by medical evidence and or psychological evidence. So say the person was tortured and has physical scars on their body. They should have filed some sort of documentation, even from the United States, like from Physicians for Human Rights, for example, that says, I've examined this person and these doctors do this for free as a volunteer service, and the scars on this person's body are consistent with the torture that he or she has reported, for example. Or that's true of female genital mutilation. Yes. A woman says that this procedure was performed on her. Doctors can easily recognize by examining the woman whether this is true or not and put it in the report. Also, therapists, counselors, psychologists, psychiatrists can, if the client, the respondent who's applying for asylum, is working with one of these doctors or healthcare providers, they can write an explanation about about the psychological suffering this person's experiencing and how it relates back to what happened to them in their home country. And that's very, very important. And so all of that strengthens the case. The client is still going to have to say what happened. Now, and by hopefully someone with this level of suffering has a lawyer, and the lawyers prepared them, but at a minimum, they have to say what happened, such as, I was tortured or I was raped. Now, how much detail they'll have to give really depends on the parties that are there. The lawyer, on how many questions the lawyer for the Department of Homeland Security has, on how many questions the judge has. But if the person just starts crying and can't answer, it's going to be very hard to go forward with the case. So if you are the lawyer and you can convince your client that they just have to say this one time, and this is the hearing, this is it today, and to just bring all their strength to do that, because the judges will, if a person can't talk, we can't finish the case. And so it just prolongs the misery for the individual and prevents the case from being resolved. I know that it's very, very hard, but it does, it's kind of a no-win situation for the judge if a person just starts crying and crying. The judge will give a break, but at some point they have to
have a testimony.
Yeah,
no, it just keeps bringing back some memories of those difficult cases and the challenges there are, especially when their trauma is so significant that they just don't want to talk about it. How about situations when the person has a disability? How is the court, or how did you deal with situations like let's say they had like a head trauma, or they didn't really have schooling growing up. They worked in the fields. Even if in their own language, they're not as they don't speak well.
Yes. Well, that the judges aren't doctors or special education expert. You need an evaluation by someone to say that that's the case, because the case law is quite sympathetic to an individual like that. And if they only have a second grade education, or if they have some intellectual disability, it would be normal that they couldn't explain in great detail what happened to them. And then hopefully there's another adult who can give testimony. And I've definitely had this where the respondent himself was significantly disabled mentally and not able really to speak, and the mother knew exactly what had happened and gave testimony, and it was all prepared in advance. She had filed a written affidavit in advance. That I think the judges are open to doing. Again, it has to be set forth in advance, and there has to be some evidence from the professional in showing what exactly what sort of additional assistance the person needs in telling their story. And while you're on that, I just wanted to mention one other thing, which goes to your point, which is sexual abuse. It's very, very common. I'm sure you know, and I knew this even from private practice before becoming a judge, that for people not to disclose that initially, because it's so humiliating and so horrific. And this goes for men and women. And often then when 2 years later, 3 years later, 4 years later, when the case finally comes to a final hearing and the person's developed a good rapport with their attorney, in the final preparation, they will disclose it. Not only were they arrested and beaten while they were in jail, but while they were there, they got raped by the guards. So again, put in a new written statement. Explain that. Why didn't the client disclose it? They were humiliated. They were and then after I gained the trust in my attorney, and my attorney explained to me how important it was to say everything, I took courage and I disclosed this, but I've never told anybody else, or whatever the true story is. So it's very common that comes out late, but again, you want it in writing in a way that it's with the explanation of why it's coming out late, so that your client can put their best foot forward in the hearing and not be so not appear like they're just adding this at the last minute to make their case stronger.
Yes, and pre-COVID, I used to do frequently detention visits. And this is, I always tell like new lawyers and lawyers that are now in immigration practice, like a declaration is really the heart of the case. You really just have to listen. And I've come across situations and stories where even like, especially with males, like even their spouses don't even know about an incident that happened in their childhood of sexual abuse and things like that. That does make a case stronger. And so it's so important to have patience with your client and just listen to them, because that's going to provide that safe place. It's going to give them that comfort that you actually do want to listen to their story, because sometimes as lawyers, we're so busy. We're like, we got to go detention, got to go visit client and okay, sign your form here and tell me what is that you fear? But actually give it some time, because it's hard, especially when it's someone new, that they're telling their story to. I had a case in Boston where the client fear was because the loan sharks in Brazil was persecuting his family, and he was a withholding of removal case. Maybe judge can explain between the difference between asylum and withholding, but the standard of proof is much higher than asylum. And I recall saying to him, I don't think we have a case for loan sharks, but he was of African descent. And he then shares with me, I'll never forget that it really was one of those days I was driving back home and really going over my gratitude list. Like how grateful I am to have a roof over my head, how grateful I am to have my children. And it's just like, even though at that time I was going through my own share of things, I was just like, oh my God, I should be so thankful. And he shared a story that because of his race in Brazil, his mother worked on the streets sweeping. So that was her job. And she was beaten by the police for being African descent, for darker skin. And he saw that throughout his childhood. And that really broke my heart. And that was the race where I connected it, race, and the times he's reported the incidents about the assaults by the loan sharks. And the judge accepted that argument, which was very difficult to overcome. and we won that case. And it was just one of those moments. Had I not listened to his background and things that happened, in his childhood, I don't think I could have connected the race with the loan shark incidents.
Yes.
Yep.
Excellent. Yes, exactly.
Yeah.
Exactly right.
Judge, so let's talk about some stories. If you're willing to share or able to share, is there one or a case that stayed with you, like a specific case, obviously not mentioning names, but is there a case that you kind of like, out of the blue, you think about it like, oh, I hope that family's okay, or I hope that child, right? Because you had youth seeking what we call the SIJ or SIJ cases, special immigrant juvenile visas, now applying for adjustment. Is there a particular case you're like, oh God, I hope they're doing well? Is that comes to memory here and there?
Well, I do have one case, which was actually not an asylum case, but it was a case of a woman who had a green card, but she had been convicted of a sexual abuse of minors, serious crime. And in California, she had actually gone to jail. She was a middle-aged woman who had gone to jail and was now out of jail in California. Well, the story, she comes in, she's applying for cancellation of removal for permanent residence, which requires her to show that she deserves to remain here and that the good things about her outweigh the negative. So the story comes out that she was a foster mom. She was a permanent resident, a foster mom. She had 3 siblings. And the siblings, the kids, the older kids, they really didn't like her rules in the house. They thought she was too strict. She made them, there were curfew. You had to come home at a certain time. You had to do your homework. You had to obey the house rules. So they cooked up a plan with their younger siblings to say that she had sexually abused them because they thought then they would get sent to another house and another placement where the rules would be lighter and they wouldn't have to abide by all of these rules. And sure enough, she gets convicted. All 4, I think there were 4 siblings, all 4 say that she's done this. She goes to jail, she comes out, and then in the hearing, the kids are there. They're adults now, and they say this was the worst mistake of their lives. Not only did they not get sent to a better placement, they all got split up, and that they realized that she is their mother. She's the only mother they ever had.
Oh, wow.
And that they did this to the person who loved them the most.
Oh,
and the reason that I knew that it was true was that it was true what they were saying and that they weren't just helping her now, was that she was doing the daycare for their children. The children that had lied about her were now adults who had their own children.
Right, and you wouldn't trust someone that you're afraid of or that
who had sexually abused you with your own children. So I was able to grant the case, but it just, I said to her, I asked her the question, how can you forgive this?
Yeah.
Not only did they make those charges against you, these are children that you loved and that you were providing daily care for years.
Right.
And she said, it's because they're my children.
Oh.
It was so it really always stuck with me.
Yeah.
That's a reason to be a judge. You can exercise discretion in favor of somebody like that. And I really did think that it was justice done. It was late, but the family did seem to be reconciling themselves over the passage of many years. Yeah. So that's certainly one that sticks with me.
Well, I've learned so much. Honestly, to me, it's like we can keep going for another couple hours, but I want to tie in about your retirement and what you've been doing now. And I also, want to extend this time also for you to explain if you're doing anything professionally that you can share with us as well.
Thank you. Well, What I am doing is essentially I started a little business to work part-time, essentially helping lawyers in asylum cases, mostly in the Boston court and the Chelmsford court. And so I do two things. I do trainings where I come to law firms and I do essentially a half-day training making the case for lawyers using the law of the First Circuit Court of Appeals, which is the high court that has jurisdiction over cases in Massachusetts and has very favorable law for asylum, showing how that can be used to present approvable cases in the immigration court. So that's one thing that I do. I did it.
And I have to tell you, so we had four attorneys, including myself, and we had our paralegals, and the feedback was all positive because you open our eyes, especially with the family PSG, and to apply when we can, because sometimes especially when you're drafting asylum briefs, and one of the attorneys who does primarily our asylum case, he said, I'm going to have to redraft my briefs. And I said, you better do that and share because all your pointers was spot on. It wasn't like, okay, I can read this on a textbook. You gave very not just hands-on input and what to do, but also the knowledge that you shared was something I don't think we can get it from a textbook. It takes more than that, and the examples you gave and honestly, I think we have stronger briefs because of that. And this was like almost a year ago, I believe. So we've made some changes and thank you for that.
You're welcome. Well, that's fun. And I've been, I enjoy doing it very much because I like going around to the various law offices and meeting the lawyers and the young new lawyers and law students who've joined offices like your office. Yep. And it's inspiring to see that people are still coming to the field and they're enthusiastic and they have good skills and they want to apply those in the immigration field. And the second thing I'm doing is basically consulting on individual asylum cases. So lawyers can consult me. And I do things like review affidavits to make suggestions, review briefs, review applications in general, talk to the lawyers about strategy in terms of presenting the evidence in court, and essentially be a sounding board for ideas for avenues they might not have thought of or reinforcing ideas that they have. So consulting in that way.
And thank you for offering that because it does make such a difference when you have the right mentorship and from someone who's been on the other side or not saying that you're against us, but you're there, you're judging over cases, looking over cases, and you know what's been working and what to avoid. And again, I think especially if you're reviewing declarations, a declaration sometimes overcomes the brief because the story's so like credible. It's meaty. It has all the facts that a judge wants to see. And like you mentioned, if you think you didn't commit a crime, but you actually have a history of or something that happened moons ago and you forgot about it, and you explain in your declaration, all that can be make a difference in the outcome of your case for sure.
Yes, definitely. So I think you're right. The declaration is the single most important piece of the asylum application. It's what the judges go to first, and it should encapsulate the whole case. So, which is why I enjoy consulting on that kind of thing.
And a non-related question. So what do you do for fun, and what do you like doing besides being this amazing judge and in the consultant business now? And like, what do you do for fun? I'm curious.
Yes. Well, I have a big family. I have 9 grandchildren. They're all in Massachusetts. I spend a lot of time with them. I like gardening. I like exercise. I like languages. I'm learning French, which is not a language I speak, because one of my grandchildren is in a French immersion program.
Oh, wonderful.
And she speaks French, so I want to be able to speak to her. And I enjoy having each day be different, which is something that you really don't have as a judge, where every day you must be on the bench at
Yes.
between this hour and just trying to squeeze in all your written work and into a very fixed timeline. So it's nice having additional flexibility.
Yes. And thank you, Judge, for your time and for sharing all this knowledge, but also, your willingness to be here with us. And I hope you can come again. I hope there's another segment.
Well, thank you for having me. I enjoyed it.